Hi, this is Mark Schroeder, Head of Client Relations at GSHC Surrogacy Agency, and today I'm speaking with attorney Robert Terenzio from Florida, who's going to tell us all about the legal process for surrogacy in that state. Robert, would you mind giving us a little background on yourself and your practice?
My name is Robert Terenzio. I'm an attorney licensed in Florida and in Connecticut. Our office prosecutes only assisted reproductive technology cases. We don't do anything else. I am a member of Florida and Connecticut bar associations and their family law associations as well. I'm a member of the American Bar Association and its Assisted Reproductive Technology Committee. I have a very strong sense that transparency is needed in ART, Assisted Reproductive Technology. As such, I have lectured pretty much all over the world to doctors, other lawyers, and certainly to the infertile public about reproductive technology and how it should be done. I'm a member also of Quad A, which is the American Association of Adoption Attorneys, where I am an ART fellow. And I'm a member of SEEDS, which is an ethical organization looking again for transparency in the industry. All of the organizations that I've been involved with, all of the lectures that I've given over the years, and all of the associations that I've made with other professionals have been to make these things as transparent as possible, as safe, both legally and financially as possible, and then to be able to deliver, no pun intended, a mechanism for that parent or parents to finally go home with the baby that they've been asking for years in some cases.
Robert, would you mind giving us a little background on the surrogacy process in the state of Florida and how it works?
Florida's surrogacy statute was put in place around 1995, if I recall correctly. It has never been attacked legally. It's been very, very stable. It follows the general direction of the case law that came out of California back in the mid-1990s, which says that the surrogate is only a surrogate and is never a parent. And that assurance, that legal assurance provides a stable framework for the parents to plan ahead, for the surrogate to understand that she'll never be stuck with a child that she didn't intend to have, and for the court to feel comfortable that it's going to generate an order that's appropriate for the medical intervention that's occurred. From that framework of the statute, of course, a surrogacy agreement is generated listing what everybody is going to do and is promising to do over the next year or so, not the least of which certainly is what's going to happen in the third trimester. Between the time that the agreement is executed in the beginning of the third trimester, hopefully nobody's calling me, because if they're calling me, there's a problem. And I don't want problems. I'd like to think that we're just dealing with the doctors at that point, the reproductive end at the very beginning, and then beginning week 10 or so with the obstetrician. But at the beginning of the third trimester, the law office gets involved again. We'll be doing two things, more or less contemporaneous with each other. We're letting the hospital know that there's going to be a surrogacy birth at their facility. We're going to let them know that we're going to obtain a pre-birth order to provide, if nothing else, the identity of everybody that is participating. And we confirm with them that the facility is large enough that when the delivery occurs, the parents can have a room for themselves and for their child as they wait for discharge to go home. So that happens on the hospital side. On the legal side, we're going to go to court. We present the judge a copy of the surrogacy agreement, an affidavit from the doctor confirming where the genetics of the child to be born originated. The pre-birth order or a pre-birth order is generated, and it says a number of things. Most importantly, that the contract conforms to Florida law, that the identified parents either are or one of them is a genetic parent, and that the hospital is to recognize them as the parents of the child when the child makes his or her presentation into the world. And then it reserves the right to revisit the issue in the future. And the reason why it makes that reservation is because Florida vital records will require a post-birth order from which to generate a birth certificate. So somebody like you will call me up or text me. Typically, it's like 3 o'clock in the morning that the baby has made his or her presentation into the world. And we then file for a post-birth order. We're typically in front of a judge, I'll just say within 5 days of the delivery. The judge remembers that he or she generated that post-birth order, so a lot of the work has already been done. As an officer of the court, I make an affirmation that the child is now here, delivered on a particular day at a particular facility. The judges always ask, how's the baby doing? How's the surrogate doing? And then says, okay, we're going to sign the order. And then the following day, I could pick that court order up. For our vital records, they need an original they will need an original post-birth order, which we send to them. And typically within 4 to 7 days, they will have generated an original birth certificate with no reference either to the surrogate or the surrogacy process, listing the parents as the legal parents of the child. The name will be the name chosen by the parents, and it looks like every other birth certificate that Florida Vital Records generates.
And how is this process any different if the intended parents are not married?
If they're not married, then it becomes a different issue. In all likelihood, the judge will require a home study be done. Now, we have a number of social workers that we engage, all of whom are very experienced through working with the LGBT community and with adoptions arising out of a different assisted reproductive technology arrangements, be it sharing ova or a surrogacy kind of arrangement. And so they understand what's going on already. And I think that makes it easier for the adopting couple, because the conversation is just going to be about them. How long have you been together? Tell us about your social life. Tell us about your work life. Tell us about your family life. And do you each feel comfortable that the other has a present ability to provide for the health, education, and welfare of the child? And do you each feel comfortable that that ability will extend into the future? And it's not these examinations are not graded. If you're honest, you pass. The judge ultimately only wants to look at the last sentence of the report. And the last sentence is, this couple is a loving couple who have an ability to share custody of a child in a way that we would expect any Florida couple to share custody of a child. And if that's in the document, that's the end of the conversation as far as the home study goes. Like I was going to say, like every state, but unfortunately not every state, but like California, Florida is a very LGBT friendly community when it comes to adoption. So the fact that we're talking to, in this case, a lesbian couple, is not a factor at all. There's no need for people to feel uncomfortable because they feel that they might be looked down upon because of their living arrangement. It doesn't happen either in the court level, and most certainly not from the social workers that we engage to do these kinds of studies.
Robert, generally speaking, how long does the parentage process take in Florida?
You know, we do these in Miami. Miami has a unique way of cataloging adoption cases, and that administration takes time. So we typically will tell clients it's going to be a minimum of 21 days because that's what the clerk's office tells us. And we basically will look at who the judge is that's being assigned the case, go 21 days out, and then ask for the nearest date beyond that 21st day. And we're usually pretty good at getting it within 30 days. Not all the time, but most of the time.
Robert, can your office work with international intended parents who are not based in Florida?
Most of our clientele at this time are not from Florida. Most of our clientele are international. I would say that 70% of our clients are from another country, and probably 80% of those folks are either single or part of an LGBT couple. We have ways of engaging the court's jurisdiction so that they can come here and feel comfortable that they're getting a court order. And most certainly, if you have a couple that is relying on a Florida surrogate and is expecting a delivery in Florida, Florida absolutely will attach jurisdiction. If it is not a scenario where there is a Florida delivery, there are other ways that we can engage jurisdiction such to be able to prosecute the adoption. And the best way that I could describe it without being very boring about all of the legal stuff is most of the jurisdictions that require folks to come to Florida are themselves unfriendly either to the fact that people are single and wanting to be parents, or that they're in an LGBT couple, or that the jurisdiction doesn't like surrogacy, or that a marriage a same-sex marriage is not permitted there. And that discrimination, that discriminatory attitude opens up a number of avenues for judges in Florida to say, yes, I will listen to this petition and generate a parental order in favor of your clients.
And what are your legal costs for the entire surrogacy process, from contract phase up through parental rights?
This office breaks things into bits because surrogacy is a number of processes all strung together. So there is a contract bit, and then there is the legal work side. The contract bit, we charge $3,500 US to do. If we get past the time frame for miscarriage, if we're into the third trimester, we send out a second invoice for $3,000. And that invoice takes care of our involvement with the hospital, with the courts, with getting the pre and post-birth orders, and with obtaining the birth certificates for the parents. The only other items that have a dollar appended to them are the cost items. And those are things that require us to pay third parties for. As an example, UPS to get documents back and forth, the court filing fee, which is about $400, and then the cost of the birth certificates themselves. They're about $30 a piece. And then finally, for those jurisdictions that will require it, not all do, but some do, we take the birth certificates, send them to the Department of State where they can be apostilled. And those have a cost. The Department of State will charge for those too. So the only other legal cost really is from the reviewing attorney who is representing the gestational carrier. And here in Florida anyways, the cost is approximately $1,500. That's a one-time fee. And while we've not talked about the review, when we generate a gestational surrogacy agreement, it's sent to the parents. We give them time to review it. We set up a Zoom, Skype, or other form of communication. If translation's needed, we take care of that too. We'll review it, answer any questions that the parents might have. If amendments or changes need to be made, we'll make them then. When the parents feel comfortable, we send it to the surrogate's attorney. As I said, that's about a $1,500 fee. The surrogate's attorney will review it with their client. If there are changes that are requested, I will get those. If they're material, we'll talk to the intended parents, our clients, another time to get their approval or declination of the changes that's being requested. And if everybody is feeling comfortable, everybody will sign. Of course, clients that are international are typically going to be signing by way of a virtual notary. And we have a virtual notary in our office. And when we have everybody's signatures, we send a clearance letter to the treating reproductive clinic so that they can start the clock on the calendar for the cycle.
This has been a conversation with attorney Robert Terenzio from the law offices of Robert T. Terenzio, located in Florida. Thank you very much for watching.
GSA GSHC.